Hello, beautiful people. Welcome back to our channel. Ever since Nnamdi Kanu's case was adjourned and made public on social media, this has sparked a lot of reactions and made other learned colleagues to look into the matter, and they have this very strong view. I'm afraid it's quite a very bad one. Before we go into the newspaper to find out exactly what they got to say, like you subscribe to our channel by clicking on the red subscribe button. Beside it, you see a bell notification icon. Please go ahead, click on it to get notified as soon as we update our channel on YouTube. Well, lawyers have frowned at the decision of security operatives who have continued to prevent their colleagues from having access to the courtroom during trials. They stress that the courtroom is a temple of justice for lawyers, hence they can't be barred from having access. They noted that shutting lawyers out of courtroom is tantamount to suspending the judicial arm of government from functioning. Recall that the Department of State Services (DSS) had on Tuesday barred some lawyers from having access into the courtroom for the trial of Nnamdi Kanu, that's Nnamdi Kanu, or leader of the Indigenous People of Biafra (IPOB), at the Abuja Federal High Court. Some lawyers, including Kanu's legal representative from the United States, Bruce Fein, were denied access into the courtroom, a situation that led Justice Binta Yaka to adjourn the matter to January 2022. However, an Abuja-based human rights lawyer, Madabuchi Idam, has condemned the prevention of lawyers from gaining access into the courtroom on the 10th of November 2021. Idam described such an action as an aberration and impunity committed by the executive arm against the fundamental human rights of the entire Nigerian people. Speaking, Idam noted that the act is an infringement on the right to liberty of lawyers and also a deprivation of rights of Nigerian citizens to counsel as guaranteed under section 35 and 36 subsection 6 subsection C of the Constitution of the Federal Republic of Nigeria 1999 as amended respectively. He stated that barring lawyers from accessing the courtroom is tantamount to suspending in the entire judicial arm of government, as the courts cannot function without lawyers to present and advocate the case or the cause of their clients. According to Idam, I dare say that the action is not just undemocratic but an invitation of anarchy, lawlessness, and a sign of total breakdown of peace and order, which will ultimately affect not just lawyers but the Nigerian people at large. These and many more brazen executive rascality are characteristics of a failed state. He continued by saying, I shed tears each time I imagine what will be the image of Nigeria before the international scene, as no democratic system anywhere in the world can support such primitive abuse of power. Just a few days ago, precisely on the 19th of October 2021, the people of Nigeria woke up to the news of invasion of the home of a Justice of the Supreme Court, my Lord, Honorable Justice Mary Orderly, by state-sponsored miscreants, and here's another shameful act of the state by barring lawyers from accessing the courtroom through the machineries of the executive. These and many more irresponsible actions of the government has continued to demarcate Nigeria at the international scene, thereby reducing the country's chances of attracting either foreign investment or portfolio investment, as no sane investor will consider a country like Nigeria for investment, a country where banditry has taken over, a country where independence of judiciary is not guaranteed, a country where a lawyer is not at liberty to access the court and plead the cause of his client. Such an investor will be running a serious risk of losing his investment, knowing that the machineries of justice will not be free to do justice when needed. Barring lawyers from accessing the court under any guise must be condemned by every voice in Nigeria, as I consider it as another attempt by the executive to suspend the fundamental human rights of the Nigerian people as guaranteed by Chapter 4 of the Constitution of the Federal Republic of Nigeria 1999 and the African Charter on Human Rights human and people's rights. This is because no democratic government in the world is permitted to administer its citizens through the barrels of gun other than the provisions of the Constitution. Also, a legal practitioner based in Abuja, Anthony Ehilebo, says security operatives have no business preventing lawyers from gaining access into the courtroom, stressing that a fully robed lawyer should be unhindered and should be given unhindered access to any part of the courtroom. Ilobo urged judges to make proclamations that prevent security operatives from gaining access into the courtroom. Speaking, Ilobo said, "The security operatives have no business in the court of law other than to bring people and allow the court to administer justice. I want to put it on record that we must ask for a higher standard of our judges. And since they have control of their courtrooms, they must proclaim that those of us that are caprals caprice the temple of justice are allowed unhindered access into this temple. They have no business restricting our movement into the temple of justice, irrespective of the matter they have. When a lawyer is robed, he has the right to access anywhere in the temple of justice because he's standing for the people he represents. He should have unfettered access into the courtroom, even on matters where the witness is shaded, even in matters where confidentiality is involved. He is allowed to enter the most screened court sessions. When asked if there are provisions in the Constitution that frowns against such action, Ihiwolobo said, "I don't think there is a provision that prohibits such actions, but what the lawyer is expected to do is seek refuge under those who have the power of proclamation, which is the judge. The judges have to take responsibility for the temples they administer. If the lawyer can go before the judge in such an instance, saying, 'We have not been allowed access into the courtroom,' the judge will now make a proclamation restricting security agencies from carrying out such an action, and of course, that would immediately be implemented. If the judge today were to say the president of Nigeria is no longer consistent, that becomes a law. Once a judge is speaking and goes into proclamation, that becomes law. And like I said earlier, we must hide under this proclamation while we pressure our legislators associated with the judiciary to make laws that will protect the sovereignty of our judicial process. It's a hard one. Oh. Well, you have heard it all. Everybody's getting angry. And it's true, really. Looking at it very logically. The lawyer are for the courtroom. Their marketplace is the courtroom. They don't sell tomato, they don't sell rice. What they do is to defend their clients, both any citizen of that country. That's their work to do, to defend clients. So if you don't give them access, especially when they are fully robed and say you're gonna be called to buy, you're not a full barrister or yes, barrister or lawyers against maybe. Why are you stopping him from practicing this what he has read? Let's put in a conversation.